Yawaha, Yanka be shame, and I won't me lawyer. On one cassa, a better no mutu say the case no, why withdraw Eddie from baby. I want to make case no, Ekakono, I know into no. Why withdraw from that case no, and the essence of the bremo say, pass a papa way, or by withdraw everyone to make case no, on a nail call at the coming na say victory so bad, on the wound to me so, ebebo in kunim different na, and yeah, that's sorry, yeah, Attorney General. Or the NIS from who raised the objection against Shema Wontumi, the withdrawal from Wontumi's case. Mommy and corner, young Concotti and Sembia Corso, and no any project at the Atu screen no and at the Amamano. Attorney General raises objection to Andy Apia Kubi's withdrawal of legal service for Wontumi in the Samana Boy illegal mining case. Abusia, Entino, Attorney General or the NIS from raises objection to block the withdrawal from chairman Wontumi in the case na enya asam keto akra nti no Attorney General wa intervene oso papa we mommy yanko na yanko kuti ensem bia ekoso e political highway so unsubscribe ya subscribe na hete on the notification bell na abusuya answer na ye be kokko na ye pese ne mudi nkomo bi na open computer papa na laptop papa na we use a borrow Perosi computers and accessories ho and a laptop papa fie ne location there enye yira kwan o Kumasi Buokrom Estate Ila. Free number ya egu ye screen isu 0247 030108 and I say 0597 942 so free number screen na wenya Perosia free 0540 882 824 Perosi computers and accessories ade ba kwa ede e wo mnise so kra low budget so kra high budget obema high quality laptop na we use mommy mbonra yesem ne konkoti de course.
Thank you. In fact, I've got quite a number of you. Vance says,
the explanation is in there, right?
Thank you very much for your message. In fact, there are quite a number of them pointing to a statement that the appeal could be made. And that leads us to the next issue. I promise I'll read all the messages. There are quite a number of them. So it's being sorted out so I can have the full complement of it. But lawyer and the appeal could be this week. You applied for a plea deal with the state on behalf of your client, Bernard Enchubochiako, Chairman Wontumi, correct?
Yes.
What was the basis for that?
I applied for initiation of plea negotiations, and I want to put it in a proper perspective, so that we have not as yet even met to commence the negotiation. But under the law, as you have rightly put there, at any point in the course of the prosecution, it is either the prosecutor himself, the court may direct, the accused person may also initiate, or the lawyer for the accused person may initiate. So all these people, I have elected to initiate.
I see.
And my
so this is section 162
yes
of Act 30. That's what you are referencing.
Yes, Act 30 as amended.
As amended.
Because this whole plea bargaining is an act itself that has been amended, attached to the original Act 30 to make it Act 30 as amended with the plea bargaining act.
So you mean Act 1079 is the current reflection of the plea bargaining act?
Plea bargaining has been annexed to the original.
I see.
And therefore, I'm coming, and my presumption is that when we commence the negotiation, we will be asking for a return of an agreement that will withdraw the charges in court, pursuant to the agreed positions of the parties.
I see.
And then this be filed before the court, for the court to adopt, and upon adoption, withdraw the matter in court, and then we are all home and dry, and then we will respond to the terms of the agreement.
I see, but Section 35 of the Court Act also has some provisions on plea bargaining,
Right.
correct?
35 of the Court Act has preconditions for the negotiation and adoption, and it is not consistent with this one.
1079.
1079.
Okay.
And in law, conflict of laws, when it happens that the two laws are conflicting, the later in time takes precedent over the earlier. And that is why we are relying on the later one, which is the Plea Bargaining Act.
Which is the current reflection of the law as we have it. So subject to section 162, and I needed to establish it before I go into it. Subject to section 162B, a person charged with a criminal offense may at any time before judgment, at any time before judgment, and the emphasis is on this point, negotiate with the Attorney General for a plea agreement.
Yes.
To reduce an offense charge to a lesser offense, B, to withdraw a charge against an accused person, or to reduce the punishment for an offense charged within the law that prescribed the punishment. And then 162B, to a plea agreement under subsection 1 may provide a sentence or a range of sentences to be recommended to the court, the payment by the accused person of compensation to a victim of the offense, or C, the making of restitution by the accused person with the prior consent of the accused person.
Right.
So
which
of the options are you really looking at? Because those who are criticizing are saying
that you must plead admission of the offense before. And those who are criticizing, and that's why I'm referring them to these provisions upon which we rely in initiating the plea agreement, our pre-negotiations. So you have rightly put it there that B says that when these are the outcomes, possible outcomes. So when we start the negotiation, it is a point of filing our terms that we will indicate which of them we have agreed to choose and which outcome we expect the court to adopt.
But in going into this plea deal, which outcome out of the many options that I've read are you?
As I told you before, our focus is on doing the deal, returning an agreement that will withdraw the charges for us to have a clean slate.
You are seeking a withdrawal of the charges against Chairman Wontumi in the Exim Bank case.
Yes, so that is the motive behind our application.
But if an agreement is reached, we'll still have to go back to the courts.
Of course.
For the courts to adopt.
Once we are in court, before anything can be done at all, if our agreement is reached and we file it in court, it is the court that will adopt it and then return it as its judgment. So anyhow, it is the court that will make the necessary pronouncements.
If you are seeking to have all the charges dropped against your client in this plea agreement, you believe in the innocence of your client right from the get-go.
Well, it's not
Why
about
didn't you just allow the process to play out in court?
No.
Rather than resorting to this plea deal. That's another question to those who are criticizing you.
This is the law, and the law is available to every accused person. And it is for you to elect your which of the laws you will rely on. And it is also your duty to negotiate with the intention of the outcome that you prefer. And it is also your right to rely on any of those provisions. And it is the court, and pursuant to your agreed position, which will come through the negotiated plea agreement, it is the court that will also adopt your agreement and make a pronouncement and bring finality to the whole process.
I see. But if the prosecution also says, well, you are seeking that the charges against your client be dropped, we also want your client to pay the 30 million plus interest.
Leave that one to the negotiation. It is because I don't want us to discuss the issues in detail when we have not even met. Exactly. But when we meet, then these issues will come. All these speculations in the air, most of them are incorrect. And indeed, they are even not referring to the application that I've submitted. And the figures being mentioned here and there, they are nowhere in the application I submitted. But I have decided not to even concentrate or respond to them because we have not started. And I take them as speculations. So when we start, maybe we will discuss even possibilities and figures. But we haven't gotten there. So let us not preempt those meetings. And then let's see how we independently go into those discussions and see what can be negotiated on and what we bring out as agreed negotiated positions as that which we expect the court to adopt.
I see. And Alberto, I'll bring you on this.
Yes.
The expectation of the lawyers is that one of the outcomes, that is dropping charges against Wontumi, is what they're expecting. But then if definitely that's not going to be one that, the prosecution will also agree to.
It is not impossible. It is not at all impossible that charges will be dropped. You need to know something, that in every prosecution, there is stress and costs on every side. The prosecution has to make their case beyond reasonable doubt. That is a very high level. And there's stress and cost. They have to prepare, they have to come back. And really, even though it's a state that is paying, it's a lot of money and resource. And then there's stress and cost on the side of the defense too. I mean, he has to pay his lawyers and everything that has to happen. And if you make a mistake, you are going to go to jail. Now, the thing about plea bargain is this. It is a mutual agreement which hopes to lessen...
Senior, give me 1 minute. You see, in all these negotiations, one thing that comes to mind is that it is the worst form of agreement is better than the best form of judgment. Because again, if you go into agreement and you agree on something, even though it will not be probably the best, the relationships beyond that is better than when you go to court and then you get a judgment that pronounces one as victor and the other as vanquished. It affects relationships going beyond the judgment.
I see. Okay,
Yeah,
please.
he's right, but that's the assumption that you will lose. A judgment that acquits you is really very good. But the point here, the general point, is that it's tactical. It's a maneuver. It is something that, you see, when you go to court, it's warfare. You're going up against somebody. It's like war. Tactical means you take a certain, maneuver, which is usually aimed at reducing cost on both sides and the potential liability, stress, cost, resources, etc. It is not an admission of guilt. So note, there are plea bargains which are no guilt bargains.
Yes, especially in this one.
Okay. There are plea bargains to which are admissions of guilt. Okay. And it leads to reduced sentence. And both of them, even if the guilt is admitted, does not mean the person is guilty. Let me give you an example. It happens a lot in the US. Because there's something they call systemic racism. If you're a black man and you are put before a court on certain charges, the statistics show that the chances that you will be convicted are very high, even depending on where you are. So there are people who sometimes have not committed a crime, but they are arrested and put before court. Now, if they go through the trial, they are looking at 15 years in jail. But if they admit what they haven't done, they are looking at 2 years.
And sometimes you don't even have to admit.
Yes, sometimes that's no guilt.
Yes.
Okay, but I'm talking about the guilt one. No guilt is one thing, but this is the more difficult one, where you haven't committed a crime, but you actually admit the guilt. Because you have a system where 90% of the people who are put before court in this area, okay, on this charge, end up, in jail. And if you go through the trial, you are looking at 15 years.
You take that as insurance.
If you admit, even though you haven't done it, 2 years you go in, you are out. So I'm saying this is one of the legal tactical maneuvers that lawyers and their clients have to look at, especially in the case of Wontumi, where there is a financial.
No, please. Yes, go ahead.
Especially in the case of Wontumi, where there's a financial issue here. It says, oh, you went to take this loan, and they'll be accused of some, all kinds of things around it. And it's money. At the end of the day, I'm not saying this is what they are saying, but at the end of the day, instead of going through 2 years of trial, whatever it is, if I can pay you the money, okay, let's sit there and see what we can do about it. And I'm not talking about the details of it, but I'm saying these are some of the things that we think about. Now, Wontumi can choose to go through the trial, assert his innocence, and actually come out innocent. He can also go through the trial found guilty, but can also save everybody and just pay the money and go away. Now, in the interest of the state, if Wontumi is convicted and put in jail for 10 years, and we feed him, clothe him, give him free medical care and everything, and still the state doesn't get anything, in a sense we have lost. Right. Even though there's a justice aspect of it. Okay. But also for Wontumi, if he goes into jail for, let's say, 10 years or whatever it is, maybe if he spends the 10 years working, he will make more money than what is paid. So where there is money at stake, that's why even in criminal matters, there's restitution, there are all these plea bargain things, so that at least you can get some money back, okay, and then find a way, that is mutually acceptable. So people should understand it in the term that it's not an admission of guilt, except Wontumi and his lawyer agree that, okay, we are guilty. And then they all come out with a situation where it's mutually beneficial. I remember in the recent past, there was a huge uproar about one of those things happening. I won't mention the names. But it was because of a misunderstanding, and people thought that it was the rich people getting scot-free. No. There is always mutual benefit on both sides whenever there's a plea bargain. And if the plea bargain is unconscionable, or it is something that is beyond the pale, the judge can refuse it. So know that the state is always protected, first by the prosecutor, who is an employee of the state, and two, by the judge, who is looking at the bigger justice issue. All right? So it's a proper thing.
And three, the accused person's rights.
Oh, well, yes.
But you see, on that particular point, it's an important point that Mr. Benton makes about how this is interpreted and then the possible outcome. Because the politics of things as well as play, and I'm sure that's why you referenced what the outcome means and how that impacts on both parties. Because you have one section...
the conflict of law situation and the earlier law that is known to the public, that is what is confusing
that
them
if
to understand
in a
that
plea deal, you have to plead guilty.
Yes.
That's what you are being criticized. That if you really believe in the innocence of your client, why are you going on a plea deal? Because that's an admission of guilt.
Which is what I'm explaining.
That is the misinformation to the public. You understand? But I have not responded to that because then you waste too much time in your responses. But once there is an existing law upon which I will rely in my plea negotiations, I will just pay attention to and focus on what I'm doing.
Oh, but you should educate the public because you have the chance.
No, that is what we are doing. In fact, many times when I have had the opportunity, I have also given that indication. The last time I was on your sister station, I brought even the law to read the sessions to align with what we are doing. That is what we are doing. You understand?
This morning.
That is what we are doing. But if you are not careful, you spend all the time responding to.
I think the matter is clear, and that's why I'm bringing the politics of things because the director of communications of the MPP and majority of those who are criticizing are members of the MPP who believe who believe that what you have done is an admission of guilt. They would have rather you go on to the end of this particular the legal conclusion of this case.
Yes.
Instead of rather coming in with the plea deal. Yes.
Alfred, I have maintained, I think in the same day this came out, that and I said that it's not an admission of guilt. The law is there, and I think that the business of getting people to understand is important, and that's what we have done here. And Kofi has been very clear in saying that it's not admission of guilt. My senior has said so, so it is clear.
Yes.
Okay, it is clear. Now, even so, it's still under it's sub judice the matter.
Yeah, so we won't go into it. But I'm just saying that
I'm very mindful of it.
Yes. So the look and feel of this Wontumi matter, if you take it and strictly put it in a straitjacket, and you want to see if this is a classic corruption case, it doesn't really stand up to that test. But meanwhile, because it's political, you talk about it that way. Because one private person goes to take a loan to do A, B, C, D, and that is transactional matter. Yes, it's transactional matter. But I'm happy about the explanation of the lawyer in telling us what option he's going for. As part of the plea bargain, the options he has is looking for a withdrawal. Is that not the case?
Yes, it is.
Which then is not the same as you're going to admit guilt and all. And the reason I was saying that if you look at this case with the Exim Bank, it's not your classic corruption case because it's a transaction. You can say now in this matter that, look, I owe the bank and I will pay. That's it. Where's the crime? You understand? So I think that since it is an evolving matter, let's allow for them to engage with the state, have whatever agreement they can have, and then we'll live with the fact. If not for want of news, if not for want of good political happenings for the government. This is not a matter to be discussed because it's premature.
Yes.
Well,
I'm coming. Not you.
But we need to educate the public.
Yes, but I'm saying that. I'm saying that.
It's the angle of the conversation.
No, I'm coming. I'm not blaming you for putting it out. I'm blaming the NDC because this is supposed to be a conversation between the lawyers.
To invite them to think like.
Oh no, but LBG has his name, and then when I say NDC, you'll come in when I refer to it.
Don't invite them.
But you see, so this is supposed to be a conversation between the lawyers, but because the NDC wants to appear as if they are fighting corruption.
Okay, abusunya we ne ensema ekoso ewo political highway so Wontumi ne lawyer ena yisi ano attorney general ono so a strike ewo ne so a enye asem keto akra beda mase samoje pene kokoti sa ensem we edemai